Hi guys, this is CA Balakrishna. In this video, we will be revising prevention and operation of mismanagement. Basically, this is a very small chapter. We will be having from section number 241 to 246. First of all, what is meant by an operation? See, operation means any action that tries to take away the legal rights of the shareholders would be known as operation. Now, if at all shareholders feel oppressed, then they can file application to the tribunal. Okay, starting with section number 241, that is application to the tribunal. Who can file the application to tribunal and under which circumstances the application can be filed with the tribunal relating to this operational mismanagement? Let us see. First of all, application to the tribunal by members of the company. When members can file application to the tribunal, if they feel that affairs of the company are being conducted in a manner prejudicial to the public interest or himself or to any other member or in the interest of the company. Okay, in these cases, member can file an application to the tribunal under section 241, or if there is a material change in either management or control of the company. Okay, management means change in the top management, like managing director, whole-time director. There is change in the management. Change in the control means change in the ownership, that is shareholding of the company. That would be material change in either management or control of the company, and such change is not in the interest of creditors, debenture holders or shareholders. In these two situations, an application to the tribunal can be filed by the member. Okay, and also application to the tribunal can be filed by central government against a particular company when the central government feels that affairs of such a company are being conducted in a manner prejudicial to the public interest, or person concerned with the conduct of management is guilty of fraud or misfeasance. Okay, if central government feels that the person who is responsible for conducting the management of affairs of the company is responsible for any fraud or any misfeasance in the company, in that case, the central government can file an application to the tribunal under section 241 against such a particular person. Okay, or if the central government is of the opinion that business of the company is being managed without any sound business principles and commercial practices, or business of the company is being managed in such a way that it is causing serious injury to the interest of the trade, or the business of the company is being conducted with an intention to defraud its creditors or members. In these cases, central government can file an application to the tribunal against the company. Okay, now see, application will be filed under section 241, but what is the eligibility? That is, how many number of members must file the application? Okay, what is the eligibility criteria for filing application under section 241 will be discussed in section number 244, that is right to apply under section 241. Let us see. In case of a company having share capital, following members will be having right to apply. What is that? Lower of at least 100 members or at least 1/10 of total members. Okay, lower of these two, or any member holding 1/10 of the issued share capital. Okay, here you have to consider issued share capital, but not paid up or not the subscribed share capital. Okay, this has to be remembered by you. It is the issued share capital. These members, however, while calculating this issued share capital, you can include both equity share capital and preference share capital. Okay, these are the requirement of number of members who have to file an application. Okay, in case of company having share capital. What if company is not having a share capital? If company is not having a share capital, then at least 1/5 of the total number of members must file the application. Only then the tribunal will accept. Okay. Now, some of the important points. See, shareholding of petitioner reduced below 10% due to fresh issue which is being challenged. That means, see, if you want to make an application to the tribunal and if the tribunal wants to accept such application, you must be holding 1/10 of the share capital. That means simply you can say 10% of total share capital. Now, in the company, there has been a fresh issue of shares. Due to such a fresh issue, your shareholding has reduced below 10%. Okay, it has reduced below 10%. Now, you feel that the action of issuing new shares is operation. Okay, the activity which has resulted into reduction of your share capital below 10% is the one against which you want to initiate application under section 241. In that case, even though your share capital is below 10%, since the activity against which you want to initiate application under section 241 is the one due to which your share capital has reduced, you can file application under section 241 even if your share capital is below 10%. Hope that is clear. Okay, even though the petition will be valid only. Next, second important point, consent is reckoned at the beginning of the proceedings. See, while you are making application to the tribunal, at such point this requirement of at least 100 members or at least 1/10 of total shareholders has to be calculated at the point of making application to the tribunal. Once the tribunal has accepted the application, after accepting the application, even though some of the shareholders withdraw their application during the proceedings will continue. Okay, because the requirement, the consent has to be reckoned at the beginning of the proceedings. Hope that is clear. That is section number 244. Now there is some important points. See, if company fails to declare the dividend or company is continuously incurring losses, these two activities cannot be termed as operation. Hope that is clear. Next, section number 242. Okay, under section 241, you have made application to the tribunal. Tribunal has accepted the application. Now, tribunal has to pass the order. First of all, before passing the order, first of all it has to accept the application. Now, when will it accept the application? Okay, there must be two conditions to be satisfied if tribunal wants to accept your application under section 241. What are those conditions? You felt that the affairs of company are oppressed. Even the tribunal must also feel same. Okay, tribunal must also feel that affairs of the company are being conducted in a oppressive manner. Okay, that is the first condition. And second condition, after seeing the application, tribunal must get a feeling that I must wind up this company. Okay, the activities, the operation that is being performed by this company is in such a way that I must wind up this company. But winding up this company will unfairly prejudice the shareholders. Okay, I can't wind up the company because it will create a loss to the shareholders if I wind up the company. But the activities that the company, the operation, the kind of operation that the company is doing is in such a way that I want to wind up the company. Such a feeling the tribunal should get. Okay, these two conditions must be satisfied. Then the tribunal will accept the application under section 241. Okay, now tribunal has accepted the application. After accepting, what are the types of orders that the tribunal will pass? See, first type of order, regulate the conduct of affairs of the company. Okay, or transfer shares of the company to other members. Okay, or restrict the transfer of shares. See, presently there are certain number of members who are holding the shares of the company who are causing the oppression. In that case, tribunal will order that these members who are causing the oppression to please transfer your shares to some other members. You sell off your shares to some other members. Like that, the tribunal might order or restrict on transfer of the shares. See, the members are going to transfer the shares to particular person. If the shares are transferred to such particular person will cause oppression in the company. Thereby, tribunal can order these members not to transfer the shares to such person. Hope that is clear. Next, terminate, set aside or modify any agreement that the company has entered. Okay, between company and managing director or manager or others. Okay. Removal of managing director, manager or other director. Okay. If managing director or manager or director is causing mismanagement in the company, then the tribunal will order for removal of those persons. Recovery of undue gains made by those manager, managing director. Appoint such other directors by tribunal to report to the tribunal. Okay. Tribunal has removed the existing directors. Now, the new directors will be appointed by the tribunal. Okay. Impose cost as it may deem fit. Okay. These are the types of orders that the tribunal can pass. Next, once the tribunal has passed the order, such order must be filed with the registrar within 30 days. Okay. And if tribunal orders alteration of either MOA or AOA of the company, then company cannot, without leave of tribunal, alter MOA or AOA inconsistent with the order. Okay. If the tribunal says that you please alter your MOA or AOA, you please include these particular clauses or you exclude some of the clauses, such type of order has been passed by the tribunal. Now, the company cannot do any other alteration other than those alterations prescribed by the tribunal. Hope that is clear. If it wants to do any other alteration, then it has to first of all take the permission of tribunal. After that, it can do additional alterations to the MOA or AOA. Hope that is clear. Next, section number 243, consequences of termination or modification of certain agreements. See, here in the order passed by the tribunal, we have seen that tribunal can, one of the order that tribunal can pass under section 242 is terminate, set aside, modify any agreement between company and managing director, between company and director, between company and manager, between company and others. Okay. Now, what is the effect of such order of termination or set aside of these agreements? That will be discussed by section number 243. See, consequence of termination or modification of certain agreements. The first consequence is that such a termination shall not give rise to any claims against the company. See, in the agreement, it might have been written that if at all the company terminates the agreement, it has to pay this much of amount to the the other party. Like this, some penalty clause is there in the agreement if at all it is terminated by the company. Now, this agreement is being terminated due to the order of tribunal. Such clause will not be applicable. Okay, you cannot ask for any claims from the company as a result of termination of this agreement. So that is clear. That is the first consequence. There will not be any claims against the company. Second consequence. See, if the agreement with managing director, manager or director is terminated. See, what type of agreement the company would be entering in with these people, which would be employment agreement. Okay, if you want to appoint a managing director, some agreement will be entered with the managing director. Same would be for manager and same would be for director. If at all company terminates such agreement with the managing director, manager or director, what are the consequences? See, if company terminated the agreement under section 242 subsection 2, that is normal order. Okay, normally the company terminated the agreement. In such case, such director, managing director or manager is disqualified for appointment in that company. Okay, in that company only for 5 years without leave of tribunal. Okay, once the tribunal has passed an order of terminating the agreement with those people, that is manager, managing director and director, those persons cannot be appointed as manager, managing director or director of the same company for a period of 5 years. However, by taking prior permission of tribunal, you can appoint them during this 5 years. Hope that is clear. That is the situation if their agreement is terminated under section 242 subsection 2. What if the agreement is terminated under section 242 subsection 4a as a result of application under section 241 subsection 3? See, application under section 241 subsection 3 will be made by central government. Okay, it made the application stating that existing management is not properly managing, or they are involved in fraud or misfeasance, or there are certain 4 factors. Okay, on these 4 factors the central government has made application to the tribunal. Now, after seeing the application, the tribunal also feels that these persons are not fit and proper to be appointed as managerial people. In that case, tribunal will disqualify them for 5 years in any company. Okay, they cannot be appointed as manager, managing director or director in any other company without leave of tribunal. Hope that is clear. And now they will also not get any compensation for this termination of agreement. Hope that is clear. Next, section number 245, which deals with class action suit. Now, to whom this class action suit can be filed? It can be filed with tribunal. By whom it can be filed? It can be filed either by members or by depositors. Why it can be filed? It can be filed in the following situations. See, to restrain company from committing the following activities, the members or depositors can file a class action suit. What are the activities? First one, if company is conducting any activity which is ultra virus to AOA or MOA, or company is breaching the provisions of MOA or AOA, or company has altered the AOA or MOA, but some of the members or depositors are against this alteration. In that case, they can file a class action suit asking tribunal to declare such alteration of MOA or AOA as void. Okay, or to restrain company or director from acting on such resolution. Okay, the shareholders have passed certain resolution, but some other shareholders or depositors don't like such or against such resolution passed by the other shareholders. Then they can approach the tribunal asking the tribunal to restrain the company or director from acting on such a resolution or acting against the provisions of the act. If at all any director or any members are acting against the provisions of the act, then other members can approach the tribunal asking to pass an order restraining those members or directors from acting against the provisions of the act, or acting against resolution passed by members, or seek such other remedy. Okay, in these situations, class action suit can be filed. Now, what are the requisite number of members or depositors that has to be required for filing the class action suit? Let us see. If members want to file a class action suit, then based on number, based on shareholding, let us see. If you take based on number, at least 5% of total number of members of the company, or 100 members of the company, whichever is lower. Okay, they can file the class action suit. Or based on shareholding, in case of unlisted company, members who are holding 5% of issued share capital can file the class action suit. Or in case of an unlisted company, members holding 2% of issued share capital can file the class action suit. This is regarding the number of members that are required to file a class action suit. Okay. Depositors. In case of depositors, at least 5% of total number of depositors or 100 depositors of company, whichever is lower, can file a class action suit. And section number 246, which deals with, okay, there are some other additional points. See, if at all there are similar class action suits with other jurisdictions, then all those class action suits must be combined together, and also two class actions for same cause cannot be filed. Okay, these are some additional points. Now, under section 246, there are certain sections of winding up chapter which will be mutatis mutandis applicable even to this operational mismanagement chapter. Basically, those provisions are relating to some penalty provisions. That penalties will be applicable even here also. Those sections you can go through. By this we have completed prevention of operational mismanagement.